The City of Johannesburg has won another case in its battle with a group of workers over the legality of their employment contract conversion. The Labour Court has ruled against that group of workers who were represented by the SA Municipal Workers Union. What the court said yesterday was that it had no jurisdiction to basically grant them the relief they were requesting. Let's get the reaction now from Samwu Johannesburg Cluster Secretary Karabo Ramahuma. Karabo, very good afternoon to you. Welcome to the program. So the Labour Court saying yesterday, sorry, we can't help you. Is that the end of the road for you then?
Good afternoon, Tembegile, and good afternoon to the listeners. Perhaps let's first congratulate our comrades in Mogale City, led by Comrade Justice, for the breakthrough that they've made in relation to their strike. But secondly, we wish to state clearly that this was the first, not another. This was the first time that Samwu approached any tribunal, be it the Labour Court, Bargaining Council, or the High Court. So this is by no means the end of the road. It's the first step, and I'm sure you would have said, if you've set sight on the judgment, that the court did not dismiss our matter. Our matter have been struck off the roll supposedly for want of jurisdiction. Of course, subsequent to that, we've extensively consulted with our legal team and really to see if the court did it really apply itself correctly. We are of a strong view that the court failed to, because there's a huge amount of authority where the same court would have entertained the same matters in the case of Prasa, where people were fixed-term contract, later on converted and or transferred by the board, and the employer sought to terminate their contracts. And the Labour Court, the very same Labour Court, entertained their issue on the issue of unlawfulness. It was strange what the judge that said. It's obviously an issue that would look into, but by no means this is the end of the road. This is a minor setback. In every war, you lose minor battles so long as your focus is still there with the main war. And we are not by any chance going to relent.
Are you saying you intend to appeal yesterday's outcome?
Look, there are various course of actions that we can take. We can either appeal the outcome of yesterday. We can approach the High Court, meaning we would be agreeing with what the judgment is saying if we do that. Alternatively, we can go direct to the Constitutional Court, more so that the Labour Court judgment makes or alludes to the issue of labor rights and them being constitutional rights and how they affect. Yes.
So, quick final one, Karabo, apologies. So what is the fate now? What is the position, the situation of these 130 workers? What are they doing now, because their employment effectively ended last week?
Look, to be honest, we need not claim easy victories. It comes in bad taste, of course, to say we could not successfully interdict the employer. Of course, we know what the Labour Court has said, but that does not mean the matter has died. The members would, of course, not be reporting for duty, given what the outcomes are. However, it does not mean they are out of it. We would still, today we would meet later on with our legal team. We're supposed to meet at 12, but due to unavailability of either some on their part or some on the part of some, we had resolved to meet later, so as to make a final posture as to say where to from here. We certainly are going somewhere with this. This is not the end of the road.
Karabo Ramahuma, thank you very much for your